Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I am Michelle Itkowitz, and today we are discussing pets and emotional support animals in New York City no pets buildings. This is part 2, and it will be on emotional support animals. If you're interested in the emotional support animal part, you need to go back and listen to the last episode, episode 46, because episode 46, the pets part actually lays the foundation that you're going to need for the emotional support animal part. Before I started this podcast, I worked on a project where I was creating on-demand online classes for New York City tenants so they could learn about the laws that affect their apartments. That work was honestly some of my best stuff, but I just wasn't reaching enough people with classes. So I pivoted away from that and I started this podcast. The difference between one of my on-demand online classes and a podcast episode is that the classes were longer, more structured, and the classes had a video component. The video was not of me, but slides that illustrated the material I was teaching. Today, I'm going to embed half of the pets and emotional support animal class, the emotional support animal part, into this podcast. And as you may notice, if you're on YouTube or Spotify, this will be the second episode with video. So I'm excited to share this material with you, but I'm also interested to see if this growing audience likes having a video slide deck component to the podcast. So I'm going to put up a poll and ask you if you would like to see more video slide deck aspects to the podcast. By the way, for people who only want to listen, that's how I look at podcasting. I just like the audio part. This should be fine for you as well, but let me know. One more thing. The class was recorded before I was podcasting, and I had the Riverside FM technology to record with, so there was no way back then for me to filter out sirens and New York City noise. I was not then, and I'm not now, in a studio with a team. I'm at my desk with my cats. So I apologize in advance for the quality of the class audio. Hopefully, the quality of the content will make up for it. In the class, I mentioned a book. The class came with a 36-page booklet, and I'll put a link to the booklet in the show notes. It is, of course, free. Okay, here we go with part 2 of the class, Pets and Emotional Support Animals in New York City No Pets Buildings. Okay, so we're at about the halfway mark, and now here we are at emotional support animals. First, let's define our topic. There are many definitions out there, but I like the one on the American Kennel Club website, and again, I have citations for everything I'm saying in the book. So they say, although all dogs offer an emotional connection with the owner, to legally be considered an emotional support animal, the pet needs to be prescribed by a licensed mental health professional to a person with a disabling mental illness. A therapist, psychologist, or psychiatrist must determine that the presence of the animal is needed for the mental health of the patient. For example, owning a pet might ease a person's anxiety or give them a focus in life. The animal can be of any age and any breed. Emotional support animals provide support through companionship and can help ease anxiety, depression, and certain phobias. However, they are not service dogs. Let's make that distinction. So the Kennel Club defines service dogs as the key difference between a service animal and an emotional support animal is whether the animal has been trained to perform a specific task or job directly related to the person's disability. So service dogs are trained to alert a hearing impaired person when an alarm goes off, or to guide a visually impaired person around an obstacle. Those are service dogs. And this class has nothing to do with service dogs, as I clearly said in the advertisement for the class. If you're someone who thinks you're entitled to a service dog, you should speak to your doctor or social worker who can hook you up with an organization that will breed, train, place, supervise, service animals, which is a whole other topic. Okay, when we're talking about emotional support animals, we look to the New York City Human Rights Law, which is contained in the New York City Administrative Code. There is also, I should say, and we are on page 19, there's also a New York State Human Rights Law that's very similar to the New York City Human Rights Law, and on the federal level, there's a Fair Housing Act and other statutes. To go into those laws is way beyond the scope of this course, but those laws are there to protect you, and if you're at the point of needing a lawyer, a qualified lawyer will know how to sort through what statutes are appropriate to invoke. So before we get into what the New York City Human Rights Law does, let's just get into who it does it for. So there are certain types of housing that are not covered by the Human Rights Law. Again, if you're in a 1 or 2 family home, it might not cover you. It actually probably does cover you, because the exemption is really if the owner is living in that home with you, or in a rooming situation, if you're renting a room and the owner is living there as well. And also if you came into the housing not by an advertisement for the general public. So it's more if it's a close situation, it wasn't an advertised apartment and the owner is living there, then this doesn't cover you. So just keep that in mind. So this is how the Human Rights Law works. The Human Rights Law is triggered. It applies to, that's my highlighter, protected classes. What are protected classes and how do you know if you're in one? So the New York City Human Rights Law actually applies to more categories of people than the state or federal laws do. We have 17 categories of protected classes of people for housing. And although this doesn't relate to what we're talking about, I just want to point out a few, because people really don't understand how far-reaching the protections of the New York City Human Rights Law are. So we have your standard categories like your gender identity, race, religion, creed, sexual orientation. But there's also a lot of other categories here. Like, for instance, we have lawful occupation. So the landlord can't say, I don't want to rent to those people. They're actors, and actors don't have steady paychecks, so I don't want them. That would be discrimination based on your lawful occupation or lawful source of income. So if you get Section 8 vouchers, the landlord can't say, well, I don't take programs. I don't want to deal with all that extra paperwork. I'm not taking you. And then the status as a victim of domestic violence, stalking, or sex offenses. The landlord can't reject or refuse to renew a tenant on that basis. So 17 categories, but the one we are concerned about here for emotional support animals is the category of disability. So the Human Rights Law protects people against discriminatory practices in housing by protecting protected classes, and one of our protected classes is disability. Okay, now disability can be further broken down. So again, Human Rights Law protects against discriminatory practice for protected classes. Protected classes, we have 17 of them, and one is disability. And disability is further broken down into physical disabilities, but also another category of disability is mental or psychological impairment. So if your mental or psychological impairment rises to the level of a disability, then this law is triggered to apply to you. And how does it work? What are the mechanics of how it helps you? So if you have a mental or psychological impairment disability, then pursuant to the Human Rights Law, you have the right to ask your landlord to enter into a cooperative dialogue with you for the purposes of discussing the landlord making what's known as a reasonable accommodation of allowing you to have an emotional support animal. So now let's just break that down. So you're a protected class because you have a mental or psychological impairment that rises to the level of disability. So that gives you the right to enter into a dialogue with the landlord asking for a reasonable accommodation. Now, let's think about reasonable accommodation. If you had a physical disability, let's say that there are 3 steps that separate you from the door of your building from the elevator bank, and you have something wrong with your legs, you're disabled, and you can't walk up those 3 stairs. You have the right to enter into a cooperative dialogue with your landlord, asking them to make the reasonable accommodation of putting a small ramp. You're not asking them to rebuild the whole building. You're just asking for a small ramp so you don't have to go up those 3 stairs. And if the court considers that reasonable, sounds reasonable to me, then the landlord has to do that. But when we're talking about a mental or psychological impairment where you're having trouble existing in your apartment, your cooperative dialogue is to ask for the reasonable accommodation of allowing you to have an emotional support animal. So now we have to talk about how do you establish your case for an emotional support animal. So here's the magic formula. The tenant has to prove that the animal is necessary. Not a good idea, not wouldn't it be nice, necessary. Because of the disability, in order for the tenant to use and enjoy the apartment, the animal is necessary. So we have to look at this more closely. And again, this is where cases help us. Also, to be a reasonable accommodation, the animal can't be dangerous, make noise, cause odors. So now let's look at what the cases tell us. The 2 cases I'm about to discuss with you, now what page are we on? These are state cases. They are not city cases, but the law is the same. The wording of the law is the same, and these are appellate level cases, and they give us good guidance. So I'm on page 22. So in this Kennedy case, the judge said, the complainants, the tenants, submitted evidence that the dog helped them with their symptoms of depression. The dog helped with depression. Nonetheless, they failed to present any medical or psychological evidence to demonstrate that the dog was necessary in order for them to enjoy the apartment. So there was no medical or psychological evidence that the dog was necessary to enjoy the apartment. Another leading case. In this case, the court said to show that a violation of the human rights law occurred and that a reasonable accommodation should have been made, the complainant must demonstrate that her son was disabled. Again, you have to prove you have the disability, that he was otherwise qualified for the tenancy, and that because of the disability, it was necessary for him to keep the dog in order for him to use and enjoy the apartment. And that reasonable accommodation can be made to allow him to keep the dog. Here, the complainant failed to demonstrate through either medical or psychological expert testimony that the son required, in other words, needed, it was necessary for the dog in order for him to use and enjoy the apartment. Okay, so now we're going to approach it from steps for getting an ESA, and we're going to break it down even further. Step 1, preferably, what do you actually have to do? That's what we're talking about now. And I am on page 23. Preferably, you will obtain a letter, or even more preferably an affidavit, from a professional who is qualified to diagnose you as having a mental or psychological disability, whom you've worked with for a while. So let's get the red pen. So weak would be a letter from your GP who sees you once a year. And strong would look more like an affidavit from your licensed therapist who you've been seeing for 3 years, and I'm just making 3 years up as an example, and an affidavit by the psychiatrist that actually prescribes you medicine. That is better, obviously. So we're seeing what weak looks like and what strong looks like. Also, the more specific the diagnosis that they put in the affidavit, the better. So weak is something like tenant is depressed. We saw that from the cases we just looked at. Depression is it's become a colloquial word. It's in the common parlance. Whereas strong is more a diagnosis type language. Now, what I'm about to read you, I don't understand exactly what I'm saying. I'm pulling it directly from case law. Tenant suffers from depression, bipolar disorder, panic disorder, anxiety, panic attacks, and acute insomnia. That's a quote of where that is explaining that the tenant has a mental or psychological disability. And if the affidavit notes tenant's treatments, prescriptions, hospitalizations, that's also helpful. Now, it's also crucial that so the professional can establish the disability, but the crucial part is connecting why the animal is necessary for the tenant to use and enjoy the apartment. So weak would be a conclusory statement, like tenant needs the animal in order to use and enjoy the apartment. That's like when a fourth grader gets a project and one of the questions is, why did you like the book? And the fourth grader says, I liked the book because I enjoyed it very much. Like, it's tautological. It's a conclusory statement. It doesn't really tell us anything. Whereas look at this strong statement. Again, I pulled this from a case and I just altered it a little to protect people's privacy, although it's a published case. Without Chester the dog in the apartment, tenant has increased symptoms of anxiety and panic attacks, which make it difficult for him to engage in the daily activities of living. I, as tenant's treating psychologist, based upon my experience with tenant and my extensive experience treating such disorders, believe tenant requires, it's another word for necessary, requires Chester to fully use and enjoy the apartment. To what? Requires Chester to what? To be happier? No. To fully use and enjoy the apartment. I have documented the positive effects of Chester on tenant. When tenant has a panic attack, Chester sits on tenant's chest. See, that's very broken down. That's very granular, and it's very useful. Obviously, a less effective way to document your disability and that the emotional support animal is necessary for you to use and enjoy the apartment would, of course, be one of these websites where you pay $25 and answer 3 questions and get a piece of paper that says you are entitled to an emotional support animal. At least in this New York City housing context, that's obviously almost worthless. Step 2 for getting an emotional support animal is to, after you've documented your disability and connected it up as a need for you to use and enjoy the apartment, step 2 is getting the right animal. So choosing the right animal and being a responsible pet owner are very important things. I think the picture here says 1,000 words, but I'm going to give you another example. So I'm on page 25. So I had a client who convinced his co-op board that he was entitled to a small dog as an emotional support animal in his no pets co-op. Then the little dog bit another resident in the elevator, and the co-op board was eventually appeased, and the man was allowed to keep the dog even after the bite, the nip. But they asked the man to put a muzzle on the dog in the elevator, and the man failed to follow the muzzle rule. So the little dog bit the same resident again. And at that point, the co-op board had no choice but to withdraw its consent for the dog as an emotional support animal, and they began legal action, and the man ended up selling the apartment and moving. He and his little dog went elsewhere. But it didn't have to work that way. He could have put the muzzle on the dog in the elevator. Certainly, when the lady that the dog previously bit got in the elevator, you would think. But okay. Step 3 is the request process. So your request should, if you've received a copy of a reasonable accommodations request policy, follow that to the letter. On page 26 of the materials, I note that the New York State human rights law now requires all residential landlords to provide a written notice to tenants and any prospective tenants detailing tenants' right to request a reasonable accommodation based on a physical or mental impairment. So that's supposed to be in your welcome package or when you're considering an apartment. I'm not seeing a lot of landlords giving that, but it's supposed to be there, and I think we'll see it increasingly. So if your building already has a policy, just follow that policy to the letter. If there's a place you're supposed to submit your request, submit it to that place, and it submit what it's asking for. And then we have your request needs to document your disability and establish the need for the emotional support animal. And this is both done with the psychologist's affidavit we discussed extensively. So the affidavit takes care of that part. And then you need to suggest the type of emotional support animal that you'll get and how the accommodation will be reasonable. So this is where you're going to talk about you're going to give the dog enough care so that they won't bark. You're going to give them enough attention, how the dog will be transported through common areas in the building, and that type of thing. So the act of your request is an important step. Make sure you follow their procedures and make sure you fill all this information in before it's asked for so that the request will be presented as something that the landlord will take seriously. Although any request the landlord is required to take seriously, but it doesn't hurt to lead with your best foot on this one. Step 4 is the cooperative dialogue and written determination. So after you request your reasonable accommodation, the landlord is required to enter into a cooperative dialogue process with you. It's not a pleasant suggestion. It's an absolute requirement. So they have to attempt to accommodate your needs. And this is where topics such as the breed of the dog and policies for moving the dog through the lobby and all that kind of thing come up. Your landlord is also required to give you a written final determination identifying if the accommodation is granted or denied. So if the landlord immediately says, no, we don't have dogs here, and refuses the cooperative dialogue, or if the cooperative dialogue begins and then never ends and there's never a written final determination, they just put you off, at those stages, the landlord is already in violation of the human rights law at that point. So also, another way that the landlord could be in violation is if the landlord gives you a letter denying your request and you feel that the request should have been granted. So at that point, it might be time to go seek legal help. And so now we're talking about where to go if you think you've been discriminated against. You have options because you have one very good option. Anyone aggrieved under the New York City human rights law may file a complaint of unlawful discrimination with the Law Enforcement Bureau of the New York City Commission on Human Rights. So I have all the information for that on page 27. I have a link. This is a very good option. There's some very great attorneys there, and they have a graduated process for interacting with the landlord to try to resolve the case without it going into a full legal case. The limitation here is that there's a 1-year limitation period. So you have to go to the Human Rights Commission in time for them to file something within 1 year of the date on which the discriminatory act occurred. So you can't sit on your rights on this one. Or you could see a lawyer, not me. So the point is to help people help themselves by understanding their rights. So if they do end up in a lawyer's office, they're that much farther along with having done things correctly. At the stages we were talking about, either the landlord won't enter into the cooperative dialogue starts and doesn't end and you don't get a written determination, or you get a thumbs down and you think you should get a thumbs up. Then at that point, you'll see a lawyer who will decide what the appropriate next step is, but you always have the option for no fees at all of going to the New York City Commission on Human Rights. All right, so let's talk about some final considerations and best practices. I'm on page 28. When a tenant calls me up and they have one of these issues, the first question out of my mouth is always the same thing. What type of apartment are you in? Are you in a rent-stabilized apartment? Are you in a co-op? Or are you in a free market apartment? I'm not asking that because the law is different with respect to different apartments. I'm asking it because your strategic concerns are different. So we cover this in much more detail in the Generation Z Welcome to Your First New York City Apartment class. In general, rent-stabilized apartments and co-ops are what I call people's forever homes, as opposed to free market apartments, which are just regular apartments not subject to these systems. In a free market apartment, you only have the right to stay for the lease term, and when the term is over, if you and the landlord don't agree on a renewal, then it will take the landlord some time, but they eventually can evict a free market tenant. So that's why when tenants call me with these things, my first question is what type of apartment you're in, because I need to know what are the stakes. Are you looking at losing a rent-stabilized apartment that you could otherwise be in for the next 45 years? Or are you just looking at being evicted from an apartment where your lease is going to end anyway? Okay, just a little interruption here before we go into the final leg of the class. I'm about to go into the part of the class where I talk about whether or not you should be seeking to have your pet qualified as an emotional support animal, or if you should use something called the 3-month rule. The 3-month rule was the topic of part 1, episode 46 of this podcast. I just wanted to put in this little word here that the 3-month rule is not so simple. It's not just, oh, I had the animal for 3 months. There's a lot of different aspects to that. And that's what the entire show in episode 46 was. That's why I said you really need to listen to episode 46 before you listen to this episode 47, or at least go back and listen to episode 46, because I just don't want you to think it's, oh, just 3 months. It's not just about 3 months. There's a lot to it. When you're making the choice of which way you're going, make sure you go back and listen to episode 46 so you have a complete picture. If you are someone who qualifies for an emotional support animal, you also could try the 3-month rule route. Instead of the affidavit and then the interactive process and the whole 9 yards, maybe you just get the animal, have it openly and notoriously for 3 months, and then the no pet rule is waived. It's something to think about. It's not what I, in general, recommend. So I'm on page 30. If this is a legitimate emotional support animal situation, I am a bigger fan of asking first and adopting second for these reasons. 1, asking first is more respectful of one's landlord and neighbors. And I think that has value in today's world, especially having respect for our neighbors. 2, asking first avoids an argument that we see landlords making in these matters, which is that tenant did not manifest the need for the accommodation until they got caught with an unauthorized animal, i.e. the ESA request is an afterthought, a fallback position, a lie. 3, if the basis for keeping the animal is the 3-month rule and not that the animal is recognized as an ESA, the 3-month rule can force a landlord to sue a tenant very quickly. So the 3-month rule is a little bit more high stakes of a game. It moves very quickly and you can end up in court, and it's very stressful for people. 4, if the basis for keeping the animal is the 3-month rule and not the animal is recognized as an emotional support animal, that privilege applies only to your current animal and it's not going to apply to subsequent animals. It's just perhaps setting you up for a future fight. I think if you have a legitimate entitlement to an ESA, I think people should go through the proper channels. But again, everybody's different and you will consult with your own lawyer to decide what's best for you. Finally, I want to say that owning an animal is really a tremendous responsibility. It's a commitment of time and resources that's akin only to having a child. And having had many animals and many children, I can tell you that in some ways an animal is a bigger responsibility, because if God willing, you do your job right, your children grow and they become responsible for themselves. But an animal will need you for everything, for every day of its life. Every drop of fresh water you provide. They can't go to the sink and turn it on themselves. They need food, medical care, companionship, safety, exercise, fresh air, natural light. What's more, again, that pet will need you for these things for probably about a decade. Cats can live for 2 decades. My last Shepherd Doberman rescue, she lived to be 12 years old, and my oldest cat made it to 19. Your relationship with your animal needs to be able to withstand changes in your personal life, such as a new job, a marriage, a move. Animals are very expensive, and during the pandemic, we unfortunately saw a lot of animals adopted that ended up not in their forever homes. All I'm saying is think about it. Thanks, everybody. Okay, I hope you enjoyed the video of the class. Again, let me know. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is just terrible, because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe and give us the highest rating. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.